Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for over a decade. You can find me on all social platforms at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Wednesday, September 24th, 2025. In this week's episode, the suspected Gilgo Beach serial killer will face trial for 7 victims in a single trial. Plus, a husband accused of killing his wife walks free after posting a $3 million bond. But first, recording artist D4vd's potential link to a homicide investigation after the body of a dismembered missing teen was found in a vehicle registered to the singer. Today, we are joined by Chris Lomax, an attorney and legal analyst you can catch on multiple outlets. Chris, welcome, my friend. How are you?
Doing great. Thanks for having me as always. How are you?
I'm doing very good. I've been looking forward to this. I always appreciate hearing your thoughts on these cases. I know these are ones that all of us have been following closely. Especially this first one here out of Los Angeles is really starting to heat up, and we're going to get into it right now, but the facts are becoming more and more disturbing. A recording artist is facing scrutiny from online sleuths after the dismembered body of a teen was found in the trunk of his impounded Tesla. The grisly discovery was made after workers noticed a foul smell coming from the vehicle registered to recording artist D4vd. That's spelled D4vd, born David Anthony Burke. Authorities identified the remains as belonging to Celeste Rivas Hernandez, a 15-year-old who has been missing for more than a year from Riverside County. Since the victim's identification, the online crime community has been seeking a connection between Burke and Hernandez, uncovering private Instagram stories and online messages allegedly exchanged between the two, which have not been confirmed by law enforcement. While authorities have not announced Burke as a suspect in the victim's homicide, they did search the singer's Hollywood Hills home for potential evidence. The singer canceled tour dates after the identification of the victim and lost multiple endorsements, including high-profile deals with Hollister and Crocs. However, Burke's streaming numbers have seen a massive jump, as a macabre fascination around Hernandez's homicide, pushing the artist into the top 100 streamed artists on Spotify. Whether Burke will remain free to enjoy his increased popularity remains to be seen, but tracks like, quote, romantic homicide could certainly be used to his detriment if prosecutors deem there is enough evidence to press charges against Burke. Chris, a lot going on in this case, like I said.
Right.
And one of the things that has been highlighted by very keen observers of this case is that one of the ways that this young poor girl, Hernandez, was identified was by a tattoo that she had on her index finger were the words SHHH, matching a very similar tattoo to D4vd. But here's my question. All of this seems incredibly suspicious to me, but we have no arrest and not even law enforcement referring to it as a homicide investigation, all that even yet. What do you make of all of that? Why this kind of gray, weird area that we're in right now?
Well, Joshua, I think everything that we've seen so far would fall into the category of circumstantial evidence.
Yeah.
As compared to direct evidence of the crime. For example, if there was a weapon that would have been used to cause blunt force trauma to this young lady's head, or if there was some text message between the two of them saying, let's meet up at around the time that they believe that she died, that would be even better evidence than what we have right now. But there is a mountain of circumstantial evidence, including this tattoo, including the mother of the deceased young woman saying that she had a boyfriend named D4vd, including the fact that she seemed to be engrossed in various activities that are focused on him. But I think the difficulty is for the prosecution is that if he is a person of some level of notoriety, there are countless young ladies who could be tattooing phrases related to him on their fingers or obsessing over him. And that doesn't mean that he necessarily has committed some type of crime that's connected to those fans. But this is more, I think, a bit more than what you would expect to see under the circumstances. And the government is likely just doing the best job that they can, as they should, to ensure that they have enough evidence to charge someone with a crime to generate probable cause before they do so. Accusing someone of murder is a very serious accusation.
I so appreciate that you say that because I think it's true. I think more times than not, we're constantly looking at law enforcement saying, you know what, maybe you should have waited a beat. Maybe you should have pumped the brakes before you bring these kinds of serious charges. Because once they bring homicide charges, once they arrest somebody, then it's kind of like, full speed ahead. And it's very hard to kind of pull that back, that type of a charge once you get that big momentum rolling. And you're right. And I'm curious to you what might convince them, because here's some other stuff we know. Now there's reports, and I will say there's perhaps conflicting reports, but reports at least from media outlets that her body was dismembered. So now we're not talking about, it's a little more suspicious, I guess. It would be one thing somebody dies accidentally, an overdose, and their body is, hidden in some sort of way because people don't know how to handle it, but it's not that they took her life. But now when you're talking about her body being dismembered, the fact that it was put inside of his vehicle that was then abandoned a short distance away from his home, what do you think could turn the tide here? Or not saying that necessarily make them make a homicide decision, but at least make a decision on whether or not it was a homicide.
So the fact that her body was dismembered suggests to me that someone was trying to either cover something up or that this was not a random act of violence, right? This is a crime of passion that is rooted in some sort of either deep love or a similarly sort of, I would say, hatred, and or maybe both. And so that would connect this violence to someone who knew her as opposed to someone who met her for the very first time. It also suggests that maybe there was a relationship that was inappropriate and her death and her body and whatever her body might have revealed about that relationship needed to be destroyed. Maybe the person who committed this crime thought that dismembering her body would make her unidentifiable. Many people who commit crimes are unaware of the way that science works, the way that the law works, and that dismembering a body does not make it render it unidentifiable. But who knows what they're thinking at the time that they commit these crimes? And so I think all of that builds onto the chain of probable cause that you need to demonstrate in order to create the appropriate circumstances for an arrest. So I expect the government to run that down even further, and maybe that's what they're waiting for. They think that they have enough, but they just want to push it all the way over the line because, like you said, charging someone with a crime like murder is something that's very serious. I mean, I've had two different people in my office this week who were charged with crimes far less serious, but substantially detrimental to their livelihoods and their careers, and there was no probable cause. And those cases were dropped, but the harm was nevertheless very real to them.
Yeah. To your point, too, she was 15 years old at the time of her disappearance, but there also are reports that she may have been involved in a relationship with him when she was as young as 13. So again, towards that motive of why might somebody want to cover this up? I'm also curious, too, if it's, I keep on thinking of something like an autopsy, toxicology reports. They want to make sure it doesn't come back for some sort of accidental overdose, even though nowadays, even with an overdose, it doesn't necessarily rule out homicide. But I'm wondering if what they're waiting on really isn't all of that, but that they're just trying to put the heat on some other people who may have been a witness to it, because I doubt this was a crime committed by a single person, though it could have been. I just feel like it seems like it has all the indicators of other people may have been aware of what took place. But what say you?
I agree with that. And just to go back to your point about why this has not been deemed a homicide, I mean, imagine this. Suppose she's at someone's house and she falls down the stairs, but it's not a house where she's supposed to be.
Right.
And the fact that she fell down the stairs and died or hit her head and was severely injured and could not be taken to a hospital because then it would be revealed that she was spending time with an adult
Yep.
who was not, lawfully in a relationship with her. may have been reason for, why her body was dismembered or even disposed of in this way after she died. So that wouldn't be a homicide. It could be an accidental death that was not caused by another person. And so it could just be the way that the body was dealt with was potentially criminal and that she
Yeah.
wasn't necessarily killed or she had a seizure. Who knows?
Yeah, good point. There's still a crime here somewhere. I mean, you don't dispose of a body in this way and there not be a crime. But there's a big difference between if that death was accidental or caused by some sort of overdose or what have you. There's a big difference between a crime committed on a dead body and homicide itself. So excellent points. We will have to leave it there for now, but it seems like every passing moment has new developments on this case, and we will continue to watch it closely. Let's move to Alamosa County, Colorado, where a husband accused of his wife's murder has been released after posting a $3 million bond. Barry Morphew, who has been twice arrested in the disappearance of his wife, Suzanne, was released into the community after his supporters raised nearly $300,000 for his release. Suzanne went missing on Mother's Day back in 2020, with investigators narrowing in on Morphew as the last person to see the woman alive. However, without Suzanne's body, prosecutors were forced to drop the charges until her remains were uncovered more than 3 years later. While the mother's death was ultimately ruled by way of unspecified means, examiners noted Suzanne's bones tested positive for a cocktail of wildlife tranquilizers, which her husband allegedly had access to. Though Morphew is once again free, he will face heavy restrictions, including the surrender of his passport, GPS monitoring, and a ban on alcohol and firearms. Morphew maintains his innocence in Suzanne's slaying and is expected back in court on November 3rd for a status conference. Kind of to our last point, or last case we were talking about here, Chris, with the patience of law enforcement, and sometimes moving quickly is not the smartest pathway. And in this case, I think it's remarkable, and I want to hear your thoughts, but this case, they had charged him. It was a no-body case. They felt they had circumstantial evidence. They were on the eve of trial, and prosecutors, for a number of reasons, but partially for this because of the strength of their case, decided to dismiss. And many people at the time thought, well, that's horrific. This man's going to get away with it, or this is going to be an unsolved crime. And then they discover her remains. And then they find in the marrow of her bones this tranquilizer that is incredibly rare. And he's apparently the only person in the state of Colorado who had access to it, making their case all that much stronger. What do you think that was patience on their part or the right move? Or do you think that, tell us about how things could have turned out very poorly had they proceeded with the case before her body was discovered?
The first thing that comes to mind for me is no double jeopardy.
Yeah.
If they were to proceed with the case with the evidence that they had and he was acquitted, I think that's it.
Yeah.
Right. And just because you find more evidence after the fact as the government does not mean you get to rebring the case. And so whoever was in that office, I don't know if it was just, by sheer luck or providence or whatever it may have been, made a call and decided, look, we don't have it, or let's try to develop it more. And to some extent, I'd be surprised if his lawyers don't try to argue some sort of jeopardy is already attached theory, but I don't know if it's going to stick here. But it looks like they're going to try to do something about the fact that her body was discovered with this substance, and it's remarkable to me that he would be one of the few people who had access to, or the fact that he had access to it at all, regardless of whether other people did or not. It just seems strange. I don't think I have access to that. And so it would be a strange coincidence for him to have access to something that was found in his wife's body and had nothing to do with it.
Yeah. Yeah, that to me gives me kind of chills to think about how close this case could have come to disaster had they proceeded the first time around, and how much stronger it is now that they were able to discover her remains. Think about that. I think you're right. I think had they tried him, had he been acquitted, and had they found this evidence, and evidence that is remarkable in its link to him as being involved in her death, what would they have done? They would have had nothing, right? I mean, I
Yeah.
mean, I cannot think of a possible argument where they would have been able to resurrect that case.
I don't think you can revive it because you think about cases like O.J. Simpson, where
Yeah.
he writes a book, you know, where he
Yeah.
essentially confesses
Yeah.
to the murder. And you've had other people say things and do things after being acquitted, and it doesn't matter, right?
Yeah.
Like you don't get to rebring it. You may try it in a different forum or a different fashion, but in our criminal justice system, once the jury has spoken or the case has been, dismissed with finality in that way, you don't really get to revive it. So I think that it would have just been what it was. It's over.
Yeah. Crazy. Crazy.
Yeah.
Um, Talk to us about the fact that he is now out on bail. And as a defense attorney, how important that is, because his bond was set at $3 million cash. And recently the judge amended that, didn't reduce it, but amended it so that he could use a bondsman or a surety bond. And he was able to post that percentage, that whatever it was, 10% or so. And he's now a quote unquote free man. He's not in jail, but he's under house arrest. He's got an ankle monitor, a bunch of other restrictions. But if you're his defense attorney, how big of a win is that for his team?
Huge win. A huge one. One, I think that having a client who is out just makes it far easier to plan, to meet with him, and to strategize around the case and to prepare the case for trial. I think it also creates a different impression in the minds of the jurors who will see him coming in and out of court every day, if they can understand or perceive what his situation is, which oftentimes they can, even if the court makes efforts to try to keep that under wraps. They know, right? They can kind of tell when the marshal or the court security person is like sitting right behind him and he can't even stand up without the person jumping. It's just a different type of situation when you are in versus when you're out. And he's on house arrest, but I think he would still be treated differently to a certain extent as someone who's coming in being brought from the back, from the jail every single day for trial. So I think it is a great victory on behalf of the defendant. I think the defendant will have a different state of mind, a different clarity of mind, being free to be in his home, to do the things that he would normally do in the morning, to get ready in his own environment, not having to be awakened at 3 a.m. And brought over and eat breakfast at 4 o'clock and then thrown back into a cell that you have to go meet with him at after the fact. So I would take that any day over having someone who's incarcerated during the trial.
Yeah. Yeah, I think people who don't work in the system and having dealt with all of this, I don't think they really appreciate just how much more difficult it is dealing with somebody who's in custody, their ability to review evidence, their ability to work with you, and like you said, just kind of their overall mental health and ability to pay attention. People who are in custody going to trial, they're falling asleep half of the time because, like you said, they've got them up at 4 in the morning and they throw a peanut butter and jelly sandwich in their hand and say, "There's lunch and dinner, by the way, because you're getting back late to the court, late to the jail because we got to put you on the late bus home from trial that day."
Right.
It's
Right.
incredibly taxing on them. And then you make an excellent point too, something I hadn't even thought of. Jurors can usually tell. I remember a juror told me after a trial, even though they had dressed out the defendant in a suit every single day, he was in custody. They could tell because they said, well, he was wearing those jailhouse shoes. They
Correct.
recognized the shoes, and that gave
That's
it
right.
away, and everybody knew. But I just think that's
Look,
a psychological thing in the back of their head.
right, and even wearing the same suit all
Yeah,
the
right,
all the time, right? Because
right,
usually you don't
right.
get a full complement of
No, you're not getting a
accessories,
wardrobe. Yeah,
right? You don't get a full wardrobe, and so you throw on the same suit every single day, and they can look at the shoes. Like people are smart, and they
yeah.
have access to information more so now than they ever have before. So there's no illusion in the minds of the jurors as to whether your client's in custody or not.
Yeah. Fascinating case. I'm looking forward to it. Again, it comes back November 3rd for a status conference. We will continue to keep an eye on it. Our final case out of Suffolk County, New York, where Rex Heuermann's defense was dealt another blow weeks after a judge's ruling to allow cutting-edge DNA evidence in the suspected serial killer's high-profile murder trial. Heuermann, who's accused of the slaying of 7 women found on Long Island's Gilgo Beach, sought a dismissal of the DNA evidence and a separation of the cases. However, his defense was unsuccessful on both counts, with the judge ruling most recently that the killings were committed in a similar manner and that evidence in the cases ultimately overlaps. This will pose a major hurdle to his defense, who previously voiced concerns about Heuermann's ability to receive a fair trial, fearing the cumulative effect of the evidence from several cases stacked together. While the case still doesn't have a trial date, the latest significant rulings in the case indicate that we are hurtling towards the proceedings reaching a trial. Chris, I'm curious to hear what you think about this motion to sever and whether or not you feel that the judge made the right call here. And I know this case is so horrific, so I don't necessarily want you to put on the defense attorney hat of his defense. But is there an argument here about bootstrapping when you've got maybe, out of those 7 cases, let's say 4 of them are kind of weak, but 3 of them are really strong? Is there a concern about jurors seeing those 3 strong cases and just deciding, oh, well, he's probably guilty of the other 4 as well, too?
Absolutely. I don't see how you can see it up any other way. I mean, if a person is accused of doing a certain thing, an individual act, then the jury needs to find that they are guilty of that particular crime that's associated with that act. Once you start to compound all of these things, it is more likely that a jury would find that if you did this one, you probably did the other one too. And that's not fair. That's not how the law is supposed to work. The government has to prove the elements of each and every crime beyond a reasonable doubt in their individual capacity. And they shouldn't be viewed as a whole. They have to be viewed individually. And the question is whether trying these cases together deprives the defendant of his right to have a jury convict him or find him not guilty of every single count of every single charge. And the cumulative impact of doing this thing together is that they will probably say guilty of one, guilty of all. And I just don't think that's right. And I don't think it's fair, but I understand the balancing that has to happen in terms of judicial economy, trying similar cases together. We face these things all the time with respect to multiple defendants in the same case, multiple, crimes or even causes of action in a civil context tried together because you don't want to have to do 7 different jury trials. And even from his perspective, I could see why he might not want to have 7 different jury trials. But here, under these circumstances, if I had to choose as a defense lawyer, I would certainly choose to do them separately as opposed to get together.
Yeah. Yeah. Yeah, one of those things that you can kind of see the arguments on both sides, but it certainly did not go the defense way on this one. Another a ruling recently that did not go the defense way was there was a very long Fry hearing that they had. It lasted over several weeks, but it was only, every few days, every several weeks. And finally, the judge decided that this new kind of not new, but new to New York sort of technology used with DNA called whole genome sequencing. The judge was going to allow it for the first time in a criminal case in New York. Talk to us about what these hearings are about. Some jurisdictions call them Fry hearings, others call them Daubert hearings. Talk to us about what essentially is the question here the judge is considering.
So judges have a gatekeeping function where they are always responsible for ensuring that the evidence and the arguments that are presented to a jury are reliable and fair. And oftentimes, lawyers will present evidence that is expert in nature, meaning that a layperson would not be permitted to come in and make certain statements. Only someone who's qualified to present this type of evidence because of their background and their training and their research and their publications would be permitted to come in and testify about a certain doctrine or theory or idea that is beyond the understanding of an everyday person, right? And then even beyond that, the evidence and the information itself has to be reliable. It has to be tested. It has to be based upon theories where other people in the field have said that this is something that we can rely on and say is true. For example, if someone were to come into court and say that, 2 + 2 = 5, then the judge might say, well, why are you saying that? And he's like, well, I do math based upon the Greek approach to such and such and such. And the judge will say, well, show me someone else who has said that 2 + 2 = 5. And he said, well, it's just me. And judge will say, well, look, I appreciate that, sir, but we're not going to be admitting that to the jury because it sounds like junk science. It doesn't match up with anything else I've ever heard of in all of my 35 years of being on the bench. So, as a gatekeeper, the judge is not going to let somebody come in and say 2 + 2 = 5 because it helps to get the defendant off or helps the government prove its case. So, similarly here, with this very complex sort of DNA or scientific analysis, the judge is saying, hey, I think this is something that the jury would be able to appreciate in terms of trying to determine guilt versus not guilty, and I'm going to allow it. And so it's tough and it's hard sometimes, but it can be very powerful and persuasive, which is why lawyers oftentimes want to use expert testimony because jurors can't understand all of this difficult scientific evidence by themselves.
So they lose on the motion to sever. All 7 are going to trial at the same time. They lose on this very important Fry hearing. The DNA evidence is coming in. It really does not seem like things are looking all that great for the Heuermann defense. What do you think's happening right now? Do you think there's conversations taking place between the defense and the prosecution, even on a case of this seriousness, about some sort of plea deal?
If I'm the defense, I would certainly hope so, because things do seem to be going south. But I can also envision a scenario where the prosecution is saying our offer is for you to plead guilty to all of the counts. And then you can use that as a basis to argue for a better sentence, that you accepted responsibility, that you've come to terms with what you've done, and that you want to save the court and the citizens who will serve on the jury time and resources trying a case where you know that you're guilty. Oftentimes, when you have the evidence, the government's not inclined to do a deal if they believe that they have everything that they need to prove the case. In a case with 7 or more different people who've died, I don't envision there being a very appetizing offer being made, right?
I
think
I would agree with you on that.
Yeah, if the defense is looking for a plea deal, they probably better look somewhere else. But I think just to the actual charges has to be on the table at this point.
Yeah. Chris, it is always a pleasure. Thank you so much for coming on this week. Tell us, where can people find out more about you?
Yeah, sure. So my firm's website, www.lomaxlegal.com. We are a South Florida-based law firm dedicated to solving problems and securing justice on behalf of our clients. Also on social media at Lomax Legal. And then my personal social media is C Lomax. That's at CEELOMAX.
Fantastic. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, please check out my new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts, and we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.